that the jury is the trier of fact and the judge answers the questions of law. And in this case directly, there was too many questions surrounding the indictment and what the actual indecent liberties that happened to the children, or what that reckless disregard for life truly was. So Judge Robinson did lay out a couple of the questions that she had. Again, those 8 counts were for reckless disregard or wanton abandon for child neglect, in disregard for human life. And the judge basically said that she was unclear about what that disregard for life was. Was that the fact that the student wasn't expelled after the first incident that was recorded? Was it the fact that there were 8 still bullets in the gun? Was it the fact that there was emotional trauma for the children that were inside the room? Was it that there was a lack of response from leaders here? So the judge said, since there were so many questions surrounding the indictments itself and what was actually that disregard for life, she said that this case had to be stricken due to logistics when it comes to the law. Now again, the judge did also say that this indictment didn't express exact people, but what it did do was kind of present a mashup of legal theories. So again, over the last couple days, you remember that there have been conversations back in court about hearsay, what has been striked from the record. And it was very contentious inside court with the conversations that were happening during testimony, because again, there were so many kind of blurred lines at which could actually be said in the court at this time. And the judge reflecting that sentiment in her statements today to us. But again, ultimately, this case that we've been following now for 3 years for Ebony Parker, I could only imagine that this is a weight lifted off of her shoulder. Our crews just spoke with her minutes ago. She didn't want to go on camera, but she did say that she is just so grateful and thankful right now for the judge's decisions. Now, as it comes to the other cases we did hear today, the defense's excuse there in order to strike all these counts was the fact that these kids weren't directly named and that there weren't direct instances to make that wanton or disregard for life true. So again, breaking news, it just came out of the courtroom just moments ago, less than 20 minutes ago, the judge made this decision. Right now, the court is in recess because the jury was supposed to show up at 10 this morning for their assignment. The judge has now decided that the court will go into recess until all the jurors have arrived today, and then Ebony Parker has been excused, but the attorneys will now stay behind, and the jury will be formally told about this decision under oath and on the record, and then they will be dismissed by the judge. So again, we thought that today the case might wrap up. We didn't know that this was going to be the end result of what happened today, but this decision definitely came down a little bit quicker than maybe some were thinking. But Connor, back to you.
Yeah, it certainly did, Madison. Going into day 4, every indication was that things would proceed as they have for the last couple days. You were supposed to do a 10 a.m. live hit just to give us a brief update on where things were headed, and instead you come to us with this massive piece of breaking news. The judge has struck all 8 counts that were alleged against Ebony Parker. Now, I want to get a sense from you now, and you did mention our other crew. Brianna Fallon is standing by. She was there when Ebony Parker exited the courtroom. We will speak to Brianna live on air here in just a moment, but I want to keep Madison with us here first. Madison, can you give us a sense once again of how the courtroom reacted to this news? There have been moments during this trial where it has been crowded. I know it was early today. Anything you can tell us about the reaction to such a shocking revelation from the judge?
Honestly, Connor, when the defense made their motion this morning and then the prosecution laid out their arguments against it, and then we heard the defense's rebuttal, it truly seemed like it was up in the air on what Judge Robinson was going to decide. But the moment that she opened her mouth and started laying out some of the reasoning before she actually announced her decision, you could hear a pin drop inside of the courtroom. The second that the judge was alluding to the fact that she might be throwing out these charges was the second that we instantly saw that emotion come from Ebony Ebony Parker, and the room kind of shifted itself into this state of silence, on this state of waiting on the edge of your seat to kind of hear exactly where the judge was going to go with her statement. But the sentiments in which she was saying were pointing to the fact that she was going to point to legalities in the case that would potentially throw the case out. And again, once that decision was made, it felt like a sigh of relief in the courtroom for at least Ebony Parker and the people who have been in the courtroom this last week in order to support her. We did see some of those people that were in the stands watching, supporting Ebony Parker. They did throw their arms around each other in that moment. They did turn to each other and cry in each other's shoulders. Again, this has been a case that's been following around Ebony Parker and her family and her camp for the last 3 years. So I'm sure the emotions that they're experiencing are extremely heightened, and every single person in the room was just waiting on the edge of their seat for the judge to make that decision. But again, she had uttered the words, "There is no precedent for this case." We've said time and time again how this case was going to be historic, and those words came directly from the judge today.
Yeah, and this is an event and a case that has in many ways lacked precedent, and that continues on through the trial. Now, my next question may be based around some recency bias here, but it seems as though confusion and questions have really been a standout theme of this trial from the very beginning. There have been questions from jurors, questions from the judge, questions from lawyers about the jurors' state of mind. I mean, it really feels like there has been an air of confusion throughout. Is that a fair assessment? Is that something that you saw, and anything to add to that?
Yeah, and that was ultimately why Judge Robinson made the decision that she did make today. That was because she said there were too many questions of legal matters inside the indictment and with what was being presented by both cases, that it was just providing so much chaos for the jury that they were kind of left in a spot where they weren't really able to discern what was just exact fact versus what it was that they were truly trying to describe as that wanton or disregard for life. I keep mentioning that statement, but we do know that the prosecution's job was to prove beyond a doubt that the disregard for life was there. And as the judge had mentioned, there was just so many questions about what that exact disregard for life was that she wasn't going to put it in the jury's hands in order to make that decision. Again, the jury is just the trier of fact, so they're only able to assess the evidence and the information that is given to them by the prosecution and the defense. They're not the ones that are supposed to be hashing out what it means as to the exact statute at which they're supposed to be trying to defend. That is up to the backpacking of the judge, and that is why she made this decision today. She said that given the confusion that the jurors have already had in the past, that confusion was most likely to persist through the day today, and so she made that executive decision. I'm the one that's supposed to be the expert on the law here. My expert opinion on the law is that this just isn't clear enough.
And then another aspect that I want to ask you about that you mentioned in your initial report here is, and something we saw quite a bit yesterday and even the day before, but I felt like especially yesterday, was the emotional trauma for the other children inside the classroom and inside the school. What role did that play in the trial up to this point, and then ultimately this decision?
Yeah. Thinking about the testimony that was given yesterday by those parents, you can see that there are going to be lasting impacts to these children for, if not the rest of their life, for at least the future that they're experiencing right now. It's been 3 years, and we heard that many of those children are still in therapy or counseling today. What the defense was arguing was that there wasn't an exact list of 8 children. You remember, there are 8 counts. The defense said that the 8 counts weren't specific enough when it came to naming exact children, when it came to naming exact ages of children. And then the prosecution had argued, well, we want to remind you, first things first, the 8 counts were for the 8 bullets that were inside of the gun, not 8 students that were mentioned, but in the opening statements from prosecution, they did mention the 20 kids that were inside of Abby Zwerner's classroom that day, that 20 including the 6-year-old child JT. And since their case was based on the fact that the disregard for life was the trauma that these kids were going to experience, again, what's said in opening statements can't be viewed as to the jury as fact. So it was the prosecution's job to prove that in evidence. That's why they brought the parents of those students to come speak with the jurors and speak and give testimony. And again, the judge said that in answering, even though we did hear some of those traumas, the exact pinpoint of where that exact disregard for life just wasn't pinpointed enough for that trauma to truly be the emphasis in which the basis of those 8 counts stood on.
Okay, and last question for you, Madison, before we get to Brianna Fallon here is, you know, I know we're right in the middle of this. This just happened. We have a tendency to look forward before we fully reckoned with the moment as it stands, but we do want to ask, what's next? Do we know what's next? What does the future hold when it comes to this case?
Yeah, so up next, again, like I told you, court's in recess right now until the jury can formally come back in and be dismissed by the judge. But moving forward, what we have learned across yesterday and also a little bit of today was that there are civil cases that are now pending by those parents of the children who were inside of Abby Zwerner's classroom. I'm sure that legality will now start to move forward, and we might start to see some movement in the case. But again, during those testimonies from those parents, they said that they didn't really want to divulge much information into those civil cases. But the defense did question of whether or not they had something to gain from a possible prosecution in this, from a possible conviction in this case, pardon me, and that all of which the parents said, no, we don't have a direct positive gain from a conviction in this case. We just want justice for our children.
Okay, Madison Schlegel, incredible work all week long. That carries on into today. I'm sure that we will see you plenty today, but for now, thanks so much for this update. We'll talk to you again soon, and great work out there.
Thank you.
Okay, we're going to go to Brianna Fallon now. Brianna was outside the courthouse when Ebony Parker exited following the tossing of those 8 counts against her. Brianna, thank you for joining us. Appreciate your patience and just a summary of what you saw from Ebony Parker as she exited the courthouse.
You know, so as soon as the judge granted that motion to strike, Ebony Parker, she just was ecstatic. You can hear cries in the courtroom this moment the judge made that decision. And leading up to those moments, she walked out. We did speak upstairs inside the courthouse. I just asked her, you know, what's next for her, essentially, you know, now that, you know, this case was essentially thrown out, struck down, what's next? She said right now she wants to move on with her life. Her family declined to comment any further than that, but she said she is very happy. She was in tears, very ecstatic. Then we came downstairs. We did follow her as she walked out of the courthouse, asked her a few more questions. She didn't really have any much else to say besides, again, that she's just ready to move on with her life and put this behind her. But it was a very interesting day in court. Both defense and the prosecutors kind of went over why they believed this case should be stricken and why it should not. Again, ultimately, the judge did decide to strike it. Right now, we're still waiting outside the courtroom to hear from those attorneys. I did reach out to the Hampton Commonwealth's attorney because, again, the Hampton Commonwealth's attorney's office is prosecuting this case. I reached out for a statement, still waiting to hear back. But again, we are hoping to hear more reaction from those attorneys soon.
Speaking of the judge, and after she heard the arguments and delivered her decision, are you able to give us maybe a little bit more context around what that was like? Did the judge seem relieved, frustrated, anything about her sort of emotional disposition as she delivered this decision?
Yeah, you know, after defense, you know, put this motion up on the table, the judge kind of said that this could have been brought up yesterday, which was interesting. But I feel like a lot of why the judge decided to strike all 8 counts of these felony charges, it was just a lot of confusion just around what the charges were for. She mentioned, were the 8 charges because of the 8 bullets in the gun? Was it because of the 8 children in the classroom? So she was kind of talking about how a lot of this was theoretical and there wasn't any concrete evidence necessarily that a crime was committed, Connor.
Okay, and I briefly want to go back to Ebony Parker, Dr. Ebony Parker. She exited the courtroom straight to the car, and I'm assuming left the premises. In terms of family around her, did she have a large group of people with her? Was she accompanied by an entire family, a team? I'd love to know more about sort of her general reaction and the reaction of those around her.
Yeah, she did have a lot of family here today. They were kind of standing outside of the courtroom waiting for her to come out after that ruling came down. She came out, ran straight to one of her family members, and they just hugged for quite some time. They were crying, just again, very, very emotional with everything happening. They came out with her. I did hear them mention that she wished that her sister was here today. But again, she was surrounded by a lot of family today. A lot of family showed up to support her today. Now, again, while they didn't want to comment, they did say that at this point, they just want to put everything behind them and just move on now that the trial was struck.
I can only imagine. I mean, it has been 3+ long years, I'm sure, through the course of this process. We saw Dr. Ebony Parker, a Zoom call she had with an HR representative was played in court yesterday. We saw emotion from Dr. Ebony Parker just even in that Zoom call. In terms of what you're seeing right now around court, is there any sort of crowd left? Has this kind of, it has come and gone, such a seismic decision, and now it's on to sort of a regular day as usual in Newport News? Is there anything lingering that you can tell us about?
Yeah, I mean, again, as soon as Parker exited the courthouse with her family, they went straight over to their car. They tried to get out quickly because, again, like she was saying, she's very, very happy about this ruling, but she does want to move forward. As for what's lingering right now, we are still waiting for attorneys to come out. We're hoping to speak with prosecutors with the Hampton Commonwealth's Attorney's Office to just hear further comment and reaction about, now that this happened, now that the judge struck all 8 felony counts here today. What's next, essentially? So we're still waiting for them to exit the building, and we're, again, hoping to get more reaction for them a little bit later today.
Okay, Brianna Fallon outside the courthouse in Newport News. I'm sure we'll see you again before the day is over. For the time being, we appreciate it, Brianna. And you heard from Brianna there as she talked about sort of the reaction, cries in the courtroom after this decision was made by the judge in Newport News. I'm going to bring on our producer here now, Samantha Spinacci, who is in studio with me. Samantha, we have a look into the courtroom in Newport News, presumably on the 30-minute delay that we've been working with. Sometimes with Live Impact News, you kind of have to discuss and make decisions over the airwaves, such as the nature of a live stream. I'm wondering, is this something that we know that we can listen in on now?
I don't know if there's audio on it, but we definitely have a video source. We can try it.
Okay, let's try it. I'm wondering, with that 30-minute delay, if this will be an opportunity to hear the judge read the decision that we've now heard so much analysis of from our reporters. Let's take a listen into that courtroom from earlier this morning as this seismic piece of breaking news was presumably read by the judge. Let's take a listen.
Are we ready to call the case of Commonwealth versus Parker?
We are.
And to the media personnel, the buttons that we have to press to turn on the audio are all in place? Okay, thank you. All right, so we are calling the case of Commonwealth versus Parker. For the record, let it reflect the Commonwealth attorney is present, Mr. Jenkins, with Ms. May. Good morning to you both.
Good morning.
The defense is present, Mr. Rogers and Mr. T. Good morning to you both.
Good morning.
The defendant is present, Ms. Parker. Good morning to you both. We rested yesterday. Is there anything you need to address this morning?
Yes, Your Honor, I have 2 matters.
Okay, yes, sir.
The first is that the court yesterday, as I understood it, we agreed to admit the full and unredacted interview between Dr. Farish and Dr. Parker. I needed time to just place that on a USB drive. I have done that. It's on Madam Clerk's counter there. I understood at the time that the court had admitted it, and I just needed to provide it. But if the court had not admitted it at that time, I am moving to reopen and admit it as Commonwealth 6.
Any objections?
Not any objection to reopening for the purpose of admitting that.
That's it.
Okay, so granted, Commonwealth is reopened, and we will admit it. Does Madam Clerk have it now?
Yes, it's
Okay.
right there.
All right, and this would be 6, Madam Clerk? Yes, ma'am. Okay, so admitted, and again, this is just the full video of what's already a redacted version in evidence. Okay, and now that that's done, do you rest again, Mr. Jenkins?
Yes, we rest the reopened case, yes.
Okay, and the second matter?
The second matter, Judge, is just as a preliminary matter, I understand that the defense, pursuant to their own subpoenas, intends to call as their witness several witnesses that have already testified, including Ms. Zwerner, Ms. Kovac, Ms. Parrish, Ms. West, perhaps others. And I just want, as a preliminary matter, to point out Jones v. Commonwealth 2023 VA Act, Lexus 294, decided May 16th of 2023, which holds that it is not proper for the defense to do any impeachment when it calls its own witnesses. And so I am asking the court to instruct the defense not to do any impeachment and not to recross on matters that they already had a full opportunity to cross on. But I certainly would not object to them eliciting new evidence in their client's favor from those witnesses. But in terms of recrossing witnesses they've already crossed, that would not be proper. They're here pursuant to the defense subpoena. So I wanted to raise that issue with the court.
Yes, sir, thank you. Response?
Yes, Your Honor. We would be asking, in the event of calling these witnesses, that they be, that we be able to examine them as hostile witnesses.
Okay. And so ultimately, we will cross that bridge when we get to it. You all are entitled to call whatever witnesses you wish, and if they meet the qualifications to be declared hostile or adverse and be treated accordingly by impeaching and or leading questions, then if they meet that statutory criteria, then that'll be allowed. So Mr. Jenkins, I understand your objection now, and it'll be ongoing, and when we get there, we will address it. But again, if they meet the criteria for being a hostile witness, the court will allow them to be treated as such.
I understand. Thank you.
All right, thank you. Okay, so with the Commonwealth resting, defense asked to prepare, time to prepare their motions to strike, and we'll start with them this morning. Are we ready for that?
Yes, Your Honor.
Okay, I'm ready. Please proceed.
Your Honor, the Commonwealth has filed 8 indictments for felony abuse and neglect of children. I am going to just sort of assume that the Commonwealth is proceeding under the fact that there were at least 8 children that were abused and neglected on January 6th. Your Honor, if that's the case, I would say the Commonwealth hasn't established that there were 8 children present in the classroom on that day when this incident occurred. The Commonwealth definitely hasn't established 8 separate incidents. So we have one incident where I guess potentially the Commonwealth believes that there was 8 children present. But the Commonwealth did not present the names of 8 individual children that were in class that day. They presented no roster or role that was confirmed by any employee that was on staff that day. And more importantly, the Commonwealth is required, I'll just read the jury instructions. In this charge with the crime of child abuse and neglect, Commonwealth must prove beyond reasonable doubt found done with a bad purpose, or without justifiable excuse, or without ground for believing it is lawful. A willful act is intentional or knowing or voluntarily as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that particular conduct would likely result in injury or illegality. Your Honor, in my own words, the Commonwealth has to establish that Dr. Parker knew, and her response was, so what? I know that there is a weapon, and that there's a likelihood that children will be harmed by that weapon or firearm, and I don't care. Let whatever happen is going to happen. There was no evidence that was Dr. Parker's response to anything that happened on that day. She was brought limited information, and she responded to the information that she had. Again, I asserted at the very beginning of this, if we look at the behavior of everyone that had contact with JT on that day, they did not believe that there was a firearm. They did not believe that there was a weapon. There was testimony from Ms. Zwerner. She was the person that had the most direct contact than anyone on that day. Her behavior did not indicate that she believed that there was a weapon. She left JT in the classroom. She left other children in the classroom. Then we go to Ms. Kovac. Again, she sat with him, had her eyes on him, watched his behavior. She said it was weird, but her actions in no way indicated that she believed that there was a firearm in possession of JT. And then we consider what Mrs. West testified. She said there were some concerns. She actually observed JT on the playground with the other children. Based on her observations, she was satisfied that there was no weapon. And she only became concerned again when there was a report almost contemporaneously with the shooting that there in fact was a weapon. And then we consider the testimony of Mr. Rawls. He had a lot of contact with JT leading up to this event. On the day of the event, concerns were brought to him. He investigated, put his eyes on JT, was satisfied that JT did not present a danger of harm to the students in the classroom. Your Honor, based on the information that Dr. Parker had, she made decisions. In hindsight, those decisions actually were determined not to be the correct decisions. But that wasn't her decision wasn't an act of neglect. There was no bad purpose, obviously. She didn't intend any harm to those students. Without justifiable excuse, Your Honor, based on the information she had, she took actions that she believed were appropriate based on the circumstances. And so there was no bad purpose. There's really no excuse that we're trying to say other than she did not believe that there was a weapon, so that explains her conduct on that day. So there was no information that she had that she came to the conclusion that was going to lead to harm of her students. And then after coming to that conclusion, she decided that she didn't care, so what,
as big as
Okay,
this one.
we come out of the courthouse because we have one of the lawyers now speaking to Brianna Fallon outside of the courthouse itself. We're going to go live to that sound right now.
Often, yeah.
Yeah.
Well, that's common.
Have you ever seen it before in one of your cases?
No, not on a felony, no.
Mm-hmm.
Yeah.
And this was 8 counts, right? I mean, that's
8
pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Well, Curtis Rogers was the lead attorney on this matter. I came in to assist him. I'm happy that I was able to help him, but this is his case, and he prepared diligently, and I'm proud of him, and I'm happy for Dr. Parker.
Judge
Thank
Robinson
you.
said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes.
Yeah.
Thank you all.
Thanks.
Thank you.
Okay, brief but impactful out there, a landmark case and a landmark ruling from one of the lawyers assisting in the defense. Let's go back into the courtroom now. What we're listening to in this courtroom is a 30-minute delay of what we have had our reporters analyzing and breaking down and updating us on over the course of the beginning of this show. We are now hearing the arguments for and against that motion that was brought this morning, and ultimately we will hear from the judge as she makes her decision to strike those 8 counts. So let's go back into the courtroom on a 30-minute delay. We'll be able to watch as they go through the proceedings that led to the landmark decision that you heard one of those defense attorneys just speak about outside the court. We'll continue to monitor our cameras and our reporters outside the court in case there is more up-to-the-minute live sound. For now, back into the courtroom.
Up to the number of victims that they believe existed in this case with a maximum of 8. And certainly no indictment can be returned twice for the same victim, and that can be explained to them. But at the end of the day, the jury is the fact finder, and they can decide whether what number of victims there were, if any. And so we think it is inappropriate to try to narrow that to specific names, but rather that the jury can decide based upon the evidence that they have how many to return or to return none. I'm sorry, how many to find guilty on or to find not guilty on all. Given that the argument generally being we didn't prove there were victims, I think that's definitely false. Children, specific children were referred to, 5 of them by my count, RR, SD, GG, MG, and KS were the specific children that we referred to during the course of the trial.
Ms. Jenkins, if you go with the initials one more time, I have SD, GG, MG,
KS, and RR.
Thank you.
So we have a total of 5 children that we identified with specificity, but I'll point to the testimony of Ms. Zwerner, who said there were about 20 students in her classroom, many of whom were in her field of vision at the moment that she was shot, and I would propose that it is up to the jury whether they believe more or fewer victims exist of this crime, and so we believe we should not be required to name specific victims in either the instructions or the indictments. The argument that we did not prove age begins with a reminder of 2 things, and of course the court is aware the burden of proof at this stage is the light most favorable to the Commonwealth, but I think more importantly that circumstantial evidence is evidence. Had testimony from several parents who said that they dropped their first grader off at school, that their child was in first grade, and that they were in Ms. Zwerner's class. Ms. Zwerner testified that first graders are about 6 years old, and throughout this trial we've instructed witnesses on the record to refer to people under the age of 18 using initials, and you had several parents come in and testify using only initials of their own children. The overwhelming evidence then is that these children were under the age of 18. No, we don't have all of their specific ages, but they were first graders in Ms. Werner's class, and they were students attending an elementary school. And so I think that the proof of age has been sufficient to survive the motion to strike. There were two legal standards mentioned by defense counsel in his argument to the court. And one was that he indicated that we had failed to prove that the defendant knew of the danger. But if you consult the model jury instructions, that is not the standard. The model jury instruction for criminal negligence tells us that to constitute criminal negligence, the Commonwealth must show that the defendant either knew or should have known that the probable result of his or her acts or omissions would be serious injury or death to a child. Given that, the correct standard for the court to apply is not that Dr. Parker knew there was a danger necessarily, but that she should have known of the danger. Having said that, she did know. There were multiple warnings she received from multiple people that there was an armed student. And as I argued during the trial on several objections, whether they thought it was a toy, whether they thought it was a knife, whether they thought just the mere fact that a possible weapon is on campus should have triggered the response defined in the crisis management plan, yet it did not. So it should have known and not known. The second legal standard defense counsel left out is from the willful act definition jury instruction. And so the model on that says a willful act is done with bad purpose. That's what defense counsel pointed out, but it's with bad purpose or without justifiable excuse. And I would argue that that is the part that we rely on here. I do not argue that Dr. Parker had a bad purpose. I will concede that fact. But the law says it's either of those, a bad purpose or without justifiable excuse. And I certainly do believe the evidence has shown that she willfully omitted acts that she should have done, and that she had no justifiable excuse for that willful omission. Given that, Judge, I ask you to deny the motions to strike.
Thank you, sir. This is the defense motion, so they can have the last word. Anything additional?
Just want the court to keep in the forefront, again, the actions of everybody. Nobody acted as if there was a actual firearm. Not following school policy doesn't result in a criminal allegation. There were acts
law that the court would probably need to recess and consider, but we are where we are. Having considered this case for 4 days and listened to the motions of counsel, and the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence, such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, but breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy, somebody is given a ticket for speeding 70 and a 65, but they're stopped in a parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge would decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of fact being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness, and judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty, and that would be the question of fact. I do all this, say all this, because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the parties' understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent, which I will say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law, nor under the code of Virginia, should the legislature wish to make this a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention.
Okay, we are back here on Live Impact News in the studio, and you can see on your screen as the judge was reading her decision, Ebony Parker reacting there in the courtroom. You saw her sort of put her head down onto the table in front of her as the judge is, again, eliciting that decision to strike all 8 counts charge to Ebony Parker in this case. And again, one of the very first things that Madison Schlegel told us this morning, that phrase, no precedent for this. You heard it there from the judge in that very specific moment as we got to hear sort of a real-time accounting of what we were updated on by our reporters. Judge Rebecca Robinson making that decision there in the courtroom and the court reacting. Now, we are going to bring Madison Schlegel back onto the program here with more updates for us as news continues to roll in. Really, reaction continues to roll in to this seismic decision that we've seen this morning. Hello again, Madison. What updates do you have for us?
Yeah, Connor, obviously you just heard those words there from Judge Rebecca Robinson about the decision that she made in this case. You had mentioned Ebony Parker's reaction and how she was when that decision was made. But ultimately today, we're also hearing from the attorneys of Abby Zwerner. Not even 15 minutes ago, I have received a statement from her attorneys on Abby Zwerner's behalf. I'm going to read you a little bit of this statement here. So mind you, these next words that I'm going to say here for a little bit are coming from the mouths of the attorneys of Abby Zwerner. So their statement reads as follows. One of the many obstacles the city of Newport News placed in Abby Zwerner's path to justice was their argument that they could deny insurance coverage in our civil case because of possible criminal conduct. Today, that's no longer an excuse that the city can hide behind. This was always the Commonwealth's criminal case, not Abby's civil case. Abby complied with the subpoena requiring her testimony once again, despite the emotional toll of repeatedly reliving this tragedy. From the beginning, our focus has remained on obtaining justice in the civil court for the preventable failures that led to Abby being shot. A Newport News jury has already spoken, returning a $10 million verdict in Abby's favor that was in the civil case, remind you. The statement goes on, yet even today, the city of Newport News continues to resist accepting responsibility and delivering the justice that verdict represents. So again, those are words there from Abby Zwerner's attorneys. It kind of echoes the same sentiment that we heard after Abby testified on Tuesday. We spoke with her attorney, Diane Toscano, and Diane had told us that, again, this case was just another representation of the failure of support that Abby Zwerner saw on that day on January 6th, and this statement stands by that. Now, I don't feel that we're going to be hearing from Zwerner directly in this case. Obviously, throughout the last 3 years, in majority, in part, she's been speaking through her attorneys. So I have a feeling that this statement right here, those couple paragraphs that they sent us, is going to be the extent of what we hear from Zwerner's camp at this time. But again, those reactions are still rolling in. At the moment, we do have the 13 News Now legal analyst Ed Booth, who's on his way right here to Newport News to speak with us live to give us a little bit of an insight into the judge's thought process about this decision. Again, this decision was made on logistics of law, and Ed Booth, our legal analyst, will be here to help us sort through that conjecture to make sure that you at home can understand. Even just minutes ago, while you guys were listening to the judge's decision, I had a community member come up to me and say, hey, I've been following this case for years. I just heard the judge threw it out. Does that mean that Ebony Parker is innocent? And I said, no, what the judge ruled today was that the indictments that were brought forward by the prosecution were not outlined specifically enough, and it raised enough conjecture that it would raise confusion with the jury, and the judge did not want the jury to be making decisions on law. That was her job. And so the reason this case was thrown out was because of the multiple legal theories that this case was trying to use in order to prove that disregard for life, and she said it didn't reach that minimum. So again, people in the community here in Newport News are curious about this decision, wondering what that actually means and how it's going to move forward. But again, one of that star witnesses in this case, Abby Zwerner, who we learned today that the defense was possibly going to call back for questioning, has now made a statement on this issue. And again, her attorneys are highlighting what they say is a failure by the city of Newport News in order to claim responsibility about what happened to her on January 6th of 2023.
Okay, thank you so much, Madison. And an update for our viewers. On the screen next to Madison, you see our double boxes. On the screen is Ebony Parker in the courtroom. You see the emotion from her. You then see the emotion from others who were in the courtroom at the time. So what you're watching, again, is that 30-minute delay of the livest look that anyone has access to inside this courtroom. We just saw the judge read that decision, and now we're watching as both Ebony Parker reacts and as others in the courtroom, presumably who are connected to her, react. And you saw kind of the just the emotion sort of pouring out there for a brief moment after hearing. Now you see the prosecuting attorney who seems to be speaking to the judge here. But we'll go back to Madison. Madison, you know, I want to touch on something from Abby Zwerner's statement that I found interesting. And I know we're going to have Ed Booth, who kind of has a more erudite understanding of some of the legal technicalities that go into this. But the opening of that statement actually took an interesting path, which was that there was no longer an argument that criminal conduct could deny insurance coverage for the $10 million that Abby Zwerner was awarded in her civil suit against Newport News Public Schools. Are you able to give more insight into that? Because that's a very interesting aspect of this, in that the throwing out of this case in some ways cleared obstacles towards her getting the amount of money that she won in that civil case.
Yeah, and Connor, we kind of heard a little bit of inklings of that yesterday when we heard from the parents of students who were inside that classroom when the defense was crossing them. Again, we learned about those multiple civil cases, well, the one civil case that's now being representing multiple of those parents. Again, the defense kept asking those parents, do you have something to gain from a conviction in this case? And again, they were hoping that a conviction, they were alluding to the fact that a conviction in this criminal case could help lend to the civil case. Now, you mentioned Abby Zwerner's civil case, which again is separate from the case that's being filed by parents of the children who were inside that classroom. And now again, Abby Zwerner was originally seeking $40 million, and the court only came up with 10. So again, I'm going to leave the legal conjecture up to Ed Booth. That will be one of the first questions that I ask him here. How will what happened today impact the legalities of the funds that Abby Zwerner is expected to get from this instance and from the civil trial that she went through last year? But again, I think what you mentioned right there too in her statement, and was also echoed across the platform here, is that this reliving of trauma. Abby Zwerner opened herself up once again to be inside of a courtroom and talk about one of the most impactful days of her life, which has changed the trajectory of her life. And again, in seeing her testimony on Tuesday, you could see that reliving of memory happening in her head as she was giving her testimony. They asked her, Abby, what happened that day? And you could see the movie playing inside of her head. You could see it on her face. You could see it in her body language. And again, body language was a huge thing in this case. You spoke about it just now with Ebony Parker. Even though we haven't heard direct words from her other than she's grateful for this decision, the emotions on both sides of this case, whether that be from Zwerner, from A.B. Kovac, the reading specialist, whether that be from Dr. Ebony Parker, again, the emotions across the board here run so deep. And now they're connected to legal funds in which, again, Abby Zwerner's owed that $10 million. So again, once Ed Booth gets out here, we'll sit down with him and we'll chat legalities of the situation, not just some explaining into what the judge has decided here, but also kind of what foreground this lays for those multiple civil trials going forward and how those funds will possibly be reimbursed.
Okay, Madison Schlegel, as always, we appreciate it, and I'm sure it won't be long before we see you again. Thanks for a little bit of time here as we move towards the 11 o'clock hour. And again, we await Madison Schlegel's analysis with our legal analyst, Ed Booth, who will be joining her shortly. Thanks, Madison. We appreciate it. Okay, now we move forward to Brianna Fallon, who is also there outside of the courthouse. She has now spoken to, or at least tried to speak to, lawyers from both sides, the defense and the prosecution, as they were exiting the courtroom. Brianna, what can you tell us about what you've seen over the last half hour?
Yeah, you know, we did try to speak to prosecutors. They kind of went over that they have no statement right there. Right now. I did ask them, though, what's next now that the judge kind of struck all 8 felony charges. He said right now that is all from him for the criminal proceedings, so it's unclear if there's going to be any further situations with this case. We also did speak with defense. They were very, very, very excited about this. They mentioned how at the end, once they realized that the judge was going to go in the direction that they went in, that it was just pure excitement, pure relief was one of the words that they used, just that overall relief after 3 years of, sitting on this trial. The judge decided to strike all 8 felony counts, and he mentioned, he's not really sure what is next for Parker, but he's looking forward to seeing what happens.
Okay, so still.
What happened today with the dismissal of the case?
We believe that the correct outcome was reached, and we're thrilled for Dr. Parker. Thank you.
What was that moment like when the judge said this didn't constitute a crime, and then Dr. Parker started sobbing?
Right, yeah, it was just a relief for her, great relief for her, and we're just happy that we were part of her journey.
What's next for her?
I'm not sure, but thank you so much, everyone.
Yeah, and what was your just initial reaction, once you realized what direction the judge was going in?
Relief, happiness.
How often do you see a motion to strike succeed?
Well, I've never been in a part of a case as big as this one, but very often in misdemeanor cases, motions to strike succeed. In misdemeanor cases.
This wasn't a misdemeanor case.
Right. So,
okay.
but in felony cases, I think it's way less
right.
often. Yeah, way less common.
Have you ever
seen it before in one of your cases?
No, not on a felony. No. Yeah.
And this was 8 counts, right? I mean, that's pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Well, Curtis Rogers was the lead attorney on this matter. I came in to assist him. I'm happy that I was able to help him, but this is his case, and he prepared diligently, and I'm proud of him, and I'm happy for Dr. Parker.
Judge Robinson said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes. Thank you all. Thank you.
Yeah, and that was the defense attorney kind of talking about the reaction to this case, again mentioning just that relief that was felt once the judge decided to strike these charges. He mentioned how this could be historic. He's not sure of many times when, 8 felony charges are dismissed like that. He said it's more common during misdemeanor trials. So again, just that pure relief that we saw from defense attorneys, the relief we saw from Parker as she exited the courtroom today. There was just a lot of emotions. She was surrounded by family. So again, a very relieving time for defense and for Parker. Connor.
Okay, Brianna, I am sure it is, and we really appreciate all of your hard work out there outside of the courthouse, chasing down lawyers, making sure we have all of that reaction and up-to-date information. We appreciate it, and we'll see you later on in the day.
See them.
Okay, so that was, again, Brianna Fallon speaking to one of those defense attorneys for Ebony Parker, and that certainly stands out, that right at the end there, a landmark case and a landmark ruling. Stephen Teague said he believes that it will be, and it certainly feels that way at this moment in time. Once again, that sort of breaking news update for anyone who's joined us here recently. Judge Rebecca Robinson has struck all 8 counts charged to Dr. Ebony Parker in the Richneck Elementary School criminal trial. That is the breaking news of the day. Day 4 of the trial doesn't really get underway before the entire thing comes to a close. We've been hearing from Madison Schlegel and Brianna Fallon on the ground all morning. We appreciate all of their hard work. We appreciate all of you for staying with us as we sort of work out how the best way to bring you all of this up-to-date information as it comes into our newsroom. And no precedent. Again, another one of those statements that really stands out when it comes to what we've seen here today in this decision from the judge in this trial, and how, again, the jury is a trier of fact, and there were simply too many questions around the indictment at this time. And so after the motion that came this morning, the judge has decided to throw out all 8 counts, and for the time being, this event that we saw more than 3 years ago in January of 2023, January 6th, 2023, it closes another chapter. And as you heard there from both Brianna and Madison, what's next, we do not know. But for now, this trial is currently done. And our time with you here on ABC on 13 News Now is done. Our coverage, however, is not. We will be continuing our coverage on Live Impact News on the 13 News Now app. You can download it for free, and we are going to have our legal analyst Ed Booth on with Madison, giving us more insight, more in-depth understanding of the historical significance of this decision, of why the judge came to this decision, of what makes this case so unique. We are going to have all that coming up again on the 13 News Now app on Live Impact News, this very platform that you see here. But as for our time here on 13 News Now on ABC, we greatly appreciate everyone's patience. Thank you for staying with us. We hope to see you over on the app. If not, perhaps we'll see you at noon. For the time being, we appreciate everybody watching. Okay, welcome back to our coverage of this morning's breaking news from the Richneck Elementary criminal trial. That breaking news, a seismic update to this case and the end of this case. Judge Rebecca Robinson has thrown out all 8 counts that were charged to Dr. Ebony Parker. So this case has reached its conclusion for the time being. Whether or not this story has reached its conclusion certainly remains to be seen and is open-ended, and so we continue our coverage now. We will have Madison Schlegel with us here throughout our show, really, and she will be joined by our legal analyst, Ed Booth, at some point. Now, for those of us who are just joining us from our linear broadcast, we appreciate you continuing to watch. For those of you who maybe are just tuning in and getting this breaking news update, questions and confusion have been a little bit of a theme here as we have tried to break down why this case was thrown out. No precedent is a phrasing that the judge has used for a case like this. The jury is a trier of fact, and there were simply too many questions surrounding this indictment, and it was unclear what the disregard for life was. Disregard for life was a part of those 8 counts, and it was unclear what the disregard for life was. What was actually the disregard for life that was contained in the actions of that day? And that the logistics when it comes to the law, another one of those sort of legal phrases that we heard reported or repeated multiple times by both the judge and then Madison and Brianna as they were reporting from the ground. This was Madison say this indictment presented a mashup of legal theories. We know that throughout the course of the trial, especially day 2, there were a number of questions surrounding objections due to hearsay. It happened multiple times throughout the presentation of the cases and the questioning of witnesses by the defense and the prosecution. And then there were questions from the jury surrounding what actually had been struck from the record and what hadn't. And then the fact that the jury was coming to those conclusions as a unit created even more questions. So throughout the case, there have been questions. There was a motion to throw the trial out earlier in the trial itself, earlier in the week, that was at that time denied by the judge. This time, the motion to throw the trial out has carried through by the judge, that motion that came from the defense. We also saw, as we watched our sort of 30-minute delayed update inside the courtroom, our 30-minute delayed camera, we watched as Ebony Parker reacted to the judge's announcement, at times putting her head down onto the desk, and then really, as far as we could tell from our viewpoint, quite a bit of emotion coming from Dr. Ebony Parker. And we heard also from Brianna Fallon, who was reporting in the courtroom and then on the ground, that there were cries in the courtroom. We saw members of the viewing audience in the courtroom sort of embrace as that decision was read by the judge. So quite a bit of updates that have come from today. But another thing that we'll make sure that we mention is we heard from one of the defense attorneys for Dr. Ebony Parker. He was asked if this was a landmark case, a landmark ruling. He said he believes that it will be. I know that we have been really hammering that point, but it speaks to the significance not just of this trial, of this event, but of the decision that we have seen here today. Now, we are once again going to be joined by Madison Schlegel at some point. She is still getting everything ready for another live update with us. She is still working to connect with Ed Booth so that they can bring us more insight into this decision. For the time being, we have some of that interview that we were able to get with defense attorneys outside of the courthouse. Now, these will be 2 defense attorneys. We know that the prosecuting attorney did not have much to say. He exited the courtroom quickly and made his way off the premises and did not give a statement to Brianna Fallon. But defense attorneys did speak briefly outside of the courthouse. Let's listen into those sound bites once again right now.
Attorney T, what's your reaction to what happened today with the dismissal of the case?
We believe that the correct outcome was reached, and we're thrilled for Dr. Parker. Thank you.
What was that moment like when the judge said this didn't
Relief for her, great relief for her, and we're just happy that we were part of her journey.
What's next for her?
I'm not sure, but thank you so much, everyone.
Yeah, and what was your just initial reaction, once you realized what direction the judge was going in?
Relief, happiness.
How often do you see a motion to strike succeed?
Well, I've never been at a part of a case as big as this one, but very often in misdemeanor cases, motions to strike succeed. In misdemeanor cases.
This wasn't a misdemeanor case.
Right. So,
okay.
but in felony cases, I think it's way less
right.
often. Yeah, way less common.
Have you ever seen it before in one of your cases?
No, not on a felony. No. Yeah.
And this was 8 counts, right? I mean, that's pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Well, Curtis Rogers was the lead attorney on this matter. I came in to assist him. I'm happy that I was able to help him, but this is his case, and he prepared diligently, and I'm proud of him, and I'm happy for Dr. Parker.
Judge Robinson said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes. Yeah. Thank you all. Thank you.
Okay, so that was Stephen Teague, who was assisting with the defense team in this case, giving those comments that we have been over a couple times here, especially in the sort of more significant statements about the big picture aspects of this decision. We also have the lead defense attorney, Curtis Rogers, who spoke outside the courtroom as well.
Thankful for everybody's prayers, a lot of people praying for Dr. Parker, and obviously Mr. Teague himself. It was so beautiful. Thanks.
we'll certainly acknowledge the fact that there wasn't much that we could take from that. We were hoping that there would be a little more clarity within that soundbite, but for the time being, not much that we could gather from Curtis Rogers there. A big day for him, certainly, as Stephen Teague alluded to, how proud he is of the lead attorney, Curtis Rogers, in this case. A big day for Curtis Rogers as well. Now, we also got a statement from Abby Zwerner's attorneys. Abby Zwerner, of course, was the teacher who was shot by her own 6-year-old student on that day in January of 2023, the incident that has led to all of this. Abby Zwerner, of course, won a civil suit, won an award of $10 million in a civil suit against Newport News. In this case in particular, earlier on in the week, and we got a statement from Abby Zwerner's attorneys following the conclusion of this case and the decision by the judge. Quote, one of the many obstacles the city of Newport News placed in Abby Zwerner's path to justice was their argument that they could deny insurance coverage in our civil case because of possible criminal conduct. Today, that is no longer an excuse that the city can hide behind. This was always the Commonwealth's criminal case, not Abby's civil case. Abby complied with the subpoena requiring her testimony once again, despite the emotional toll of repeatedly reliving this tragedy. From the beginning, our focus has remained on obtaining justice in civil court for the preventable failures that led to Abby being shot. A Newport News jury has already spoken, returning a $10 million verdict in Abby's favor. Yet, even today, the city of Newport News continues to resist accepting responsibility and delivering the justice that verdict represents. Again, from attorneys Diane Toscano and her team, the attorneys for Abby Zwerner there. And of course, an interesting aspect of that statement is that first paragraph, and interesting that they led the statement with the sentiment that one of the obstacles in Zwerner's path to justice was the argument that Newport News could deny insurance coverage in the $10 million civil award because of possible criminal conduct. That possible criminal conduct has not been proven beyond a reasonable doubt, as we saw today. And so, in theory, for Abby Zwerner's legal team, that is no longer an excuse that the city can hide behind. So a little bit of an interesting aspect, a wrinkle to this, along with so many others that we hear from Abby Zwerner's attorneys, that potentially an obstacle to her getting that $10 million reward has been removed due to this case being thrown out in some way. So again, there are so many angles through which to cover this case. That is one of them, as Abby Zwerner continues to move forward from January 6, 2023, when she was shot in her own classroom. Now, we have looks inside the courtroom today. This is from earlier today, as attorneys were making their arguments for and against the tossing out of those 8 counts. And eventually this will lead to the judge making her decision. And then we did see as much of Ebony Parker's reaction as we could from the angle of our camera in the courtroom. So we'll keep an eye on that. We'll continue to play that as supplemental video throughout our coverage today. For the time being, we continue to focus as much as we can on this piece of breaking news. You know, this trial follows the civil trial. It follows everything that has come in the last 3+ years from this particular event, all the way down to the human trauma that came from the specific people that were involved, and then all the way up to the big picture ramifications, both legally and politically and socially, that come from an event like this. It has been a very long road, and today another step is taken in that journey that was somewhat unexpected. So we continue to cover as many aspects of this as we can. Again, we'll have that legal breakdown coming up for you at some point, but observing some of these sort of big statements that were given, rarely is there a movement to strike, a motion to strike in a felony case that is actually followed through upon by the judge and agreed to by the judge. Typically, that happens in misdemeanor cases. That's according to Stephen Teague outside of that trial. So, another way in which this is a unique and sort of landmark event and continues to create new precedents, as before this, there was no precedent for this sort of case, which we heard from Judge Rebecca Robinson. Now, again, we have heard from any number of different witnesses throughout the course of this case, including on day 3, which was yesterday, we heard from parents who had kids in the classroom, kids in the school. We heard from Tanisa Richardson, who had a son in Abby Zwerner's class, Ramon Sebastian Gonzalez Hernandez, who had a son in Abby Zwerner's class, Sarah Gonzalez, who had a son in Abby Zwerner's class. You obviously can pick up on the pattern there, as there were parents that were brought in who were then giving testimony about how this has impacted their children, kids refusing to sleep alone, kids who have been in therapy and counseling for up to 2 years, nightmares, losing their temper more often, having to be, again, accompanied while sleeping. And this is all a part of the case that was being built, but it also was mentioned in some aspects by the judge as she tried to sort of delineate on what was being ruled upon here, right? Unclear what the disregard for life was. Was it the bullets in the gun? Was it the emotional trauma for the children inside the room? All of that sort of coming together to create a situation where we see this this ruling from the judge this morning. So it looks like Madison Schlegel is getting ready to do another live shot with us. Ed Booth has arrived on the scene and will be joining her. And we're getting the thumbs up that we are ready to head back out to Newport News. And Madison Schlegel, once again. Madison, good to see you again. Welcome back. And before we get to Ed Booth, any more updates that we need to know?
Yeah, no exact updates. I mean, you've heard that we've gotten sound from both the prosecution and the defense in this case. Again, we've got the backdrop of the Newport News courthouse behind us. Connor, last time we spoke, you had questions about some of the statements that Abby Zwerner's lawyer passed along, as well as also some concerns about why the judge kind of made the decision that she made here in the case. And luckily, to help give us a little bit more insight to that, we've got legal analyst Ed Booth with us right now. And Ed, thank you so much for making yourself available for us and coming out, joining us here in the field to talk about this case. I mean, in hearing that the judge has dismissed these 8 counts, knowing that you've been following this case for 3 years, what was the first thing that went through your head on a legal basis?
Well, as any lawyer would think, the judge has taken the case away from the jury, which happens both in criminal and civil cases. But as soon as you hear that ruling as a lawyer, you understand that the judge has considered the facts in the law as put on by the Commonwealth and decided that the jury doesn't need to hear the case because those facts and that law, or the combination of the two, don't equate to something that should go to a jury. In other words, the judge is going to say, I'm going to take this away and make a ruling, essentially direct a verdict in favor of the defense because certain elements or certain aspects of the case wouldn't merit allowing it to go to a jury.
Right. And I think over the last couple of days, we've also seen some confusion from the jurors as well. We remember on day 2 or day 3 of the trial, we were hearing for a possible mistrial because of the jurors possibly asking questions about what was actually put on the record. When you hear that there were so many stops and starts in this case because of hearsay, because of what the statutes were actually allowing for the defense or the prosecution to bring to the table for the witnesses, what comes to your mind when you hear that the jury was kind of already questioning the information that was put on the table when they didn't even see all the evidence yet?
Well, sure. I mean, as a trial lawyer, when you're putting a case on in front of a jury, I mean, things don't always go exactly the way that you hope. That's just not the reality of trials. But, you know, a smooth progression of the evidence and something that makes sense and is easy for the jurors to follow is the ideal, right? That's what we want. And when you get something less than that, the more confusing it becomes for them, the harder it is for them to process the evidence. But ultimately, they didn't have to make any decisions because the judge essentially made the decision for them and granting the motion to strike that the defense made.
Well, I think we may have seen a little bit of an inkling of that yesterday when that motion for a mistrial came up, because obviously that was presented by the defense, but it was the prosecution who said, I actually think I agree with that. And that's what caused the judge to go into recess for a bit. So knowing that there were kind of agreements in the confusion, is that kind of common in a case like this, especially when we've got a case that's so contentious as the one that is here?
It's not super common. I mean, sometimes one side wants a mistrial, the other side is opposed. closed. Occasionally, you have something where, both sides are kind of like, okay, we got a problem. I mean, that can happen in both civil and in criminal cases. Is it real common? No. I mean, generally speaking, one side saying, please give us a mistrial, the other side saying, no, you don't need to do that. Whatever happened, because happen for a lot of reasons, right? Whatever happened isn't bad enough or serious enough or doesn't warrant granting a mistrial, and that the trial should continue. Now, I wasn't there yesterday, but my understanding from what you just told me is that the Commonwealth is saying, well, okay, that could be an issue. So, clearly there was at least some common ground in terms of what had happened during the conduct and course of the trial that at least gave both sides a little bit of concern. But it sounds like, ultimately that wasn't granted, and the judge went on to grant a motion to strike, which is a different motion entirely, and an important one typically made in criminal trials.
Well, that was going to be my next question for you. I just want to get kind of some clarification for the people at home on what this truly means. This decision doesn't mean Ebony Parker is guilty or innocent here. It kind of just means that the judge has found that there's not enough for this case to kind of stand on, correct?
Well, yeah, it's called a motion to strike the evidence, but basically it's a motion to dismiss the case because the prosecution hasn't met whatever the elements of a particular crime are. So, I mean, think of it, we call it a motion to strike, but in essence it's a motion to dismiss. So, that kind of motion is always made by the defense to say, Judge, we don't need to go any further. We don't need to put on any evidence. We don't need to have a jury consider anything because the elements of the case aren't here. I mean, I'll give you a perfect example. I mean, if somebody was charged with arson, but the Commonwealth failed to prove, that the fire occurred by arsonist means, in other words, was intentionally set, that's a core element of the crime. And if you fail to prove that, well, that case shouldn't go on to a jury, and a defense shouldn't have to put on any evidence. So it can happen for a lot of reasons, but it's very important because jeopardy has attached, witnesses have been sworn. So, this is the end of the case, but it's the end of the case because the judge has said that there was something that wasn't met in terms of the prosecution's proof.
Do you think that this might open the door for another case? Is that something that could happen here? Or do you think that since this has kind of been the decision, this issue won't be brought up again in the courts? Could the Commonwealth bring it up again?
Well, it's double jeopardy applies. I mean, when you swear witnesses and begin the trial, that is a trial. And people aren't tried twice for the same crime or set of facts and circumstances. So, no, I think this is the end.
So even if they were to, I mean, given the basis that it was standing on those 8 counts in the indictment that were brought up, could the prosecution potentially come up with different indictments, or again, is that something that's not really typical?
You're going to charge someone, with crimes based on a certain set of facts and circumstances. You do it all at once. You don't get to pick away at different pieces. I mean, the idea is that we don't find different ways to try people for the same set of facts.
Well, and that's exactly why we have you here today to answer those kind of questions, because I know that those are things that are milling around in the minds of the people who are watching this trial unfold. But we also kind of heard from Abby Zwerner's attorneys today too. They had referenced that civil case that had happened last year where she was granted that $10 million, and also an issue of insurance that the city was kind of claiming as well. I know before we got on camera here, you gave me a little breakdown about what that means in a case like this and how what came out of this case right here could possibly play into a factor of that. Do you just mind giving me a little snapshot?
Well, sure. Criminal and civil cases are very different. What happens in a criminal case doesn't necessarily impact a civil case. Sometimes admissions made that are part of a criminal case can sort of carry over into a civil case, but generally speaking, they're separate. You have an independent result in the one, and it's separate and apart from the other. But as to your question regarding insurance, when you have a government defendant, a school system, there's basically 2 sets of we'll call them insurance companies. They're labeled a little bit differently, but for all intents and purposes, that's what they are. When you have a defendant who's been charged with or convicted of a crime, sometimes those insurance companies effectively will say, well, no, we're not going to provide a defense for you. We're not going to give you a lawyer. We're not going to provide indemnity if you were to be found responsible for that conduct. I've seen it happen in my cases before, and criminal charges are one of those bases here. So that effectively removes conviction of a crime from an argument that could be made, in favor of not providing insurance. Now, the charging is different and the conduct is different, but at this point there is no conviction.
Well, we heard some of that kind of argument come from the defense yesterday when the parents of the children who were inside that classroom took the stand yesterday. One of the biggest questions that the defense asked every single one of them was, do you have something to gain from a civil case that you have now filed in this situation? Do you have something to gain from a conviction in this case, in that civil case? And many of those parents said no. And I think it begs the question of really, even though Abby Zwerner's civil case has been wrapped up, we know that on the back burner there's this other civil case with those parents that's still open, that still hasn't been heard yet. How do you think that this outcome today will impact those cases moving forward?
Well, I don't know that it will impact it in any meaningful way other than what we just talked about in terms of potential impacts on the coverage. The questions that you described, they're kind of classic bias questions. It's, do you have kind of a dog in the fight? Is there something that could happen here? And sort of the reverse is true, right? Because, on the one hand, if the conduct is the same, those parents might say, well, we want to see justice, or words along, that line. But on the other hand, if the goal is to have a recovery in a civil case for a child, well then, you want a source of funds to get that. I mean, it's sort of like, if you're in a car accident and the person who hit you doesn't have any car insurance and you don't either, well, that's a problem, right? And that, you've got kind of a double-edged sword here. But the questions that you described, it's classic bias. Do you have a reason to want an outcome, and you always hear that in criminal and in civil cases.
The last kind of question I've got for you before I turn it back to Connor to see if he's got any questions in-house for you. The judge also said directly in this case that there's no precedent to follow here. Obviously, over the last 3 years, we kept hearing the word, this is an historic case. Knowing that with the background of what we've heard today and knowing what's unfolded over the last 3 years, not that this is necessarily a bow on it at all, but what would you say about how the lack of kind of precedent or other cases that have been seen like this, how that impacts what we've seen today as well?
Well, it's just, obviously, it garnered the national attention that it's garnered because of how unusual it is, and then, of course, the criminal and civil cases that have spun off of it. So, yes, it is unusual. It's not the kind of garden variety, case involving, children and abuse and neglect and endangerment that you see, unfortunately all the time. I mean, we have those cases every day. They're being heard right down the street, and nobody has an interest in them because it's just, sort of garden variety, awful things that happen in society. But this is different. The charging mechanism is different. The theory of the case is different. So in that sense, there isn't a playbook that, that a prosecutor or a defense attorney can go to and say, well, oh, this is what has happened in the last 5 similar trials, because there aren't any. And that doesn't mean that, this can't be the first. Obviously it was. It just means that, it isn't a situation where, we know what happens in a case like this, because there just aren't a lot of them.
Does this lay the ground for a future case then?
Well, I don't know. I mean, I guess it depends on what your point of view is, right? Obviously the prosecution was unsuccessful in this particular case. It doesn't mean that a case under a similar theory couldn't be charged in the future. These are all independent based on their own facts and the prosecutorial discretion as to whether or not it's appropriate to bring charges. So, prosecutors will continue to do, what they feel is right, which is, seek justice for convictions that they feel like they can reasonably obtain on the evidence. That's their role. And, defense attorneys will defend those cases. That's theirs.
Perfect. Well, Ed, this conversation here is so helpful. I know not just for me, but I'm sure for the people who are watching back at home too. And Connor, again, you've heard some of that analysis there about why the judge made the decisions that she possibly did. I just want to ask you, obviously we've got Ed here for us. Do you guys have any questions back there in the studio that maybe you'd like me to ask him?
Yeah, absolutely. This is going to be something unique for us. I'll relay the question to Madison. She'll relay it to Mr. Booth, and hopefully we'll be able to get an answer. We heard Stephen Teague, one of the defense attorneys, talk about how he has seen this in misdemeanors. He has not seen this in a felony trial. I'm wondering why that is the case. Why is this even more rare for a felony trial for us to have this conclusion, for this motion to strike to be approved by the judge?
Yeah, the defense attorneys in their questioning outside when they came out of the courthouse basically said that they've seen this happen in misdemeanor cases, but not technically felony cases. Can you give us a little bit of insight about that?
Well, I wasn't there and I didn't hear their comments, so I'm not sure exactly what facts or circumstances they were talking about. Can you give me a little bit more information on what exactly they meant in the distinction between felony and misdemeanor?
Yeah, because these were felony charges that were brought against Ebony Parker. Because of that, he said that this was the biggest case, one of the biggest cases that he's ever got to try.
Right.
So in the past, he's mostly seen this kind of situation play out in a misdemeanor kind of scenario. So watching this play out on a felony type of level, is that rare, or is that different, or is that maybe to be expected?
As I understand the question, obviously it's a felony, so it's a much more serious charge. It carries the potential for more serious prison time. It's tried differently. Misdemeanors are tried in front of district court judges, and that's a trial in front of the judge rather than in front of a jury. The presentation of the evidence is different. You don't have jurors and the considerations that go along with that. Everybody there knows the rules of evidence, and and you have a judge who's able to sort of disregard things that are inadmissible and consider things that are admissible. So in some sense it's a simpler case to put on. When you put on a felony charge in front of a jury, there are a lot of considerations that go into that. So I think maybe what they were saying, if I understand it correctly, is that we've seen theories like this more often appear in cases where the consequences were comparatively less. I think maybe that's the best way to interpret it.
All right. Well, Connor, there's your answer via our game of telephone. Hopefully I relayed that properly for you. Do you've got any other questions or qualms that you would like me to ask Ed Booth for you?
I do. And my qualm is that I have to keep doing this to you, Madison, where you're kind of listening and repeating. But in terms of questions, right? When we saw that confusion earlier in the case, jurors were confused, which led to lawyers having some questions. A lot of it came over the objections due to hearsay, what was on the record, what wasn't on the record. I know that Mr. Booth was not in the courtroom day in and day out, but does that confusion on day 2 and into day 3, what role does that play in this decision here? How big of a factor was that in the judge making this decision?
Yeah, we touched on that a little bit, but I have no problem asking that kind of question again. Connor's just basically curious. Obviously, we mentioned the confusion that the jury had about what was being struck from the record and what was able to keep on it. In the sense of knowing that there was confusion amongst the jury, does that kind of speak to the fact that the prosecution maybe didn't lay the grounds properly about what they needed to be defending here?
Well, it doesn't necessarily mean that. You have a lot of cases in a trial where, something is said during a witness's testimony, and the judge strikes that and says the jury will disregard that. And the extreme example when something is said is, okay, we're going to go ahead and grant a mistrial, we're going to start the whole thing over again. And for some very serious things, constitutional violations, that's really the only remedy. You have to grant that mistrial. But there are some things where the court may say, like, I'll give you an instruction on that. You're not to consider that. And we have to trust that the jury is going to follow the judge's instructions. And when the judge says you're not to consider these things, you're only to consider these things, that the jury is going to follow what the judge said. So, you have layers of, of sort of corrective action that a court can take. The most extreme being, the mistrial. There's nothing that we can do to fix this. It's broken beyond repair. We have to start over. The more mild is don't consider that. That's not something for your consideration. I know you heard it. We can't unring the bell, but you're not to consider it, and then we have to trust that the jury will follow that rule.
All right, Connor, substantial enough answer for you?
That was more than substantial. My last question for you, just from what is it like to be a lawyer who has been involved in a case like this and is now walking out of the courthouse? I mean, what is that feeling like, win or lose, to have reached this conclusion, to have put in all this work, and then to get a ruling like this and be walking out of the courthouse trying to grapple with all of that?
Yeah, obviously over the last 3 years this has played out, and for many of these attorneys, they've lost sleep over this, hours and hours that it takes to put together a case like this. And knowing that the answer that they got today was that this case was going to be dismissed, if you put yourself into the mind of the attorneys that were walking out of the door today, maybe either side, the defense or the prosecution, what would you say about maybe their feelings about knowing how big, how fruitful this case was, and then kind of having that lifted off their shoulders in just a moment?
Well, I mean, that's the life of a trial lawyer. I mean, if you try cases in front of juries, you've been there. You felt that. You felt it on all sides of it. You do the very best that you can do. You put on the case that you can put on. It's ultimately either in the hands of the jury or in the hands of a judge. And at the end of it, you got to look back and say, I did everything that I could do with the evidence and the facts that I had. These were the decisions that are made, and we've got to accept it and move on. I mean, that is our system, right? You got to go and you put your case on. You do the best you can, and a judge or a jury decides it. And yeah, I mean, there's amounts of time that are put into it, money in many cases. That's true in civil cases and in criminal cases. So, but that's the job, right? And I'm sure that they were having all the thoughts that those of us who try cases in front of juries have: disappointment, excitement, depending on which side that you're on, and then you move on, and there'll be another trial.
The air of acceptance, yeah, definitely. Acceptance we've seen on both sides of those parties today. Again, we heard from Ebony Parker that she feels grateful for this decision. And in the case of Abby Zwerner, she still feels like the city of Newport News has disregarded her actions, the actions that led up to that day. So again, the acceptance in this case kind of falls on both ends of the spectrum right now. But Connor, that's what we've got to give you here. If you've got any more questions, I will field them to Ed Booth here. But in the meantime, we're going to keep you updated on everything that's happening and work to put all this together for you to make sense of it for not only our noon broadcasts, but also our evening broadcasts as well.
You guys are the best. Ed Booth, Madison Schlegel, we appreciate you so much. Thank you for the game of telephone. Thank you for all of that insight. And Madison, thank you for your work all week on this case. And I'm sure we'll see you later on this afternoon.
Thanks, Connor. I appreciate it.
All right, so there you have it, our legal analyst, Ed Booth, with a little bit more of a breakdown into what we've seen this week. And, of course, Madison Schlegel has just done, we're sort of running out of superlatives that we can apply to the work that she has done this week. She has been in that courtroom day in and day out, coming down from the courtroom to give us updates, running back up to the courtroom to lock back into the trial, and doing everything that she possibly could to make sure that we have all of the updates and information that we need, and we certainly have throughout the course of this week, including this morning's seismic piece of breaking news that the judge has decided to throw out all 8 counts charged to Dr. Ebony Parker in this case, and that case has come to its conclusion after just barely 4 days, 3 days and some change, really, for this case to take place in Newport News. Okay, let's take a commercial break here on Live Impact News. Let's go to commercial. When we come back, we're going to continue to we're going to look at our itinerary here. We're going to make sure that we have given you all the information that we can on this story. We do have live events going on, but we want to make sure our coverage is as thorough as possible here when it comes to a case that is a local case, a local incident, and one that has had national implications and national attention on it. So let's take a break, and then we'll meet back here in the studio in a couple minutes. All right, we're back here on Live Impact News, continuing with our coverage of this morning's decision by the judge to throw out all 8 counts charged to Dr. Ebony Parker in the Richneck Elementary School criminal trial. Now, we are making sure that we have this fully covered. We have been over it now for about 2 hours here, just shy of 2 hours. So there have been a lot of different elements that we have looked into. We are going to have Brianna Fallon live with us here once again. Brianna was in the courtroom as everything broke down, as everything was decided, and then she made her way to just outside of the courtroom as lawyers and family and Dr. Ebony Parker were each exiting and making their way to their cars. She was able to talk to some of the lawyers. Some did not want to give statements. The prosecution in particular did not have any statements. He made his way off the premises rather quickly. Defense attorneys stayed for just a little bit longer and gave very, very brief statements, and then she was able to talk to Ebony Parker in the courthouse, though Ebony Parker did not stick around to speak to reporters outside. So we were able to get at least an update from Dr. Ebony Parker about her state of mind. However, she did not talk on record at any point. Again, this is tied to the January 6, 2023 school shooting that injured teacher Abby Zwerner. Abby Zwerner was shot by one of her own students, a 6-year-old in her class. There was a civil trial that ended up awarding Abby Zwerner $10 million, and now today a criminal trial that has been officially thrown out. There is another civil trial still to come, as a group of parents of other children in that school have brought a civil trial, and we have heard a lot throughout this trial from some of those parents about the trauma that this event inflicted on their children and the lasting effects that it has had on their children, especially in terms of struggling to sleep, struggling with nightmares, struggling being alone, things of that nature. So the human element of this story certainly continues to loom large, even as we move through so many judicial technicalities. There are a lot of legal language to work through. Obviously, the decision in this case has been described as landmark in some ways. It has been described by the judge itself as a case with no precedent, so it can be really easy to sort of be consumed by the big picture elements of this situation. But this case has also had a way of bringing us right back to the tragic and devastating human element that came as a result of January 6th, 2023. Parker had been accused of failing to act after multiple warnings that 6-year-old student had brought a firearm to school on the day of the shooting. Prosecutors allege she did not follow safety procedures and did not alert the principal or initiate a search of the student himself. But the decision brings an end to that case, which included testimony from not just parents, but school staff, Newport News City public school officials, and evidence involving some of those school safety policies and an internal investigation and the findings that came from that. We saw yesterday actually a Zoom call that had taken place prior between one of the human resources administrators investigating the case and Dr. Ebony Parker. A Zoom call in which Dr. Ebony Parker did show quite a bit of emotion while describing some of the events of that day. We saw more emotion from Dr. Parker in the courtroom as the judge read her decision aloud. Dr. Parker at one point putting her head down on the table, at another point in time sort of being comforted by her legal team as she really showcased some major emotion, which, I mean, what else could you possibly expect in a decision like this, in a case like this? During the trial, jurors heard accounts from school personnel and families describing the aftermath, testimony about reporting procedures, response protocols inside the school, a lot of discussion about what were the rules for a situation like this, what were the responsibilities for a situation like this. That played a major role in this decision. Okay, let's transition back out live to the courthouse. Brianna Fallon is here with us from Newport News. Brianna, you've been in and out with us all day. We really appreciate all your time and all of your patience, all of your reporting here. Any updates you can give us from the last time we saw you? We know things have calmed down quite a bit out there.
Things have definitely calmed down quite a bit, but again, the emotion that we were seeing earlier this morning after the judge made her decision was incredible. You know, there was just so much emotion, family of Parker's emotion, and if you actually want to take a look at your screen, you could see video that we took as Parker exited the courthouse. We did try to get a few statements from her during that time as she exited, but she did take a pretty quick pace to her car there. While she didn't say much on camera, I did speak to her outside of the actual courtroom before she walked outside this morning. She said she is very relieved with the verdict here today, with that motion to strike, and that she's just ready to move on with her life at this point. So it's not very clear what is next. We did also get to speak with defense attorneys and the prosecutors as they left the courthouse. Prosecution didn't have too much to say here. I did get the chance to ask what's next, essentially, and he kind of shut it down, saying that this is where the end of the line is for him in this case. We also did speak to defense, as I mentioned, and he mentioned how much of a relief this is for Parker, but also to his team, that the judge decided to strike down all 8 felony counts. Take a listen for yourself.
Any comments or reaction to what happened today with the dismissal of the case?
We believe that the correct outcome was reached, and we're thrilled for Dr. Parker. Thank you.
What was that moment like when the judge said this didn't constitute a crime, and then Dr. Parker started sobbing?
Right, yeah, it was just a relief for her, a great relief for her, and we're just happy that we were part of her journey.
What's next for her?
I'm not sure, but thank you so much, everyone.
Yeah, and what was your just initial reaction, you know, once you realized what direction the judge was going in?
Relief, happiness.
How often do you see a motion to strike succeed?
Well, I've never been in a part of a case as big as this one, but very often in misdemeanor cases, motions to strike succeed. In misdemeanor cases.
This wasn't a misdemeanor case.
Right. So,
okay.
but in felony cases, I think it's way less
right.
often. Yeah. Way less common.
Have you ever seen it before in one of your cases?
No, not on a felony. No. Yeah.
And this was 8 counts, right? I mean, that's pretty significant. Can you talk a little bit about that and kind of coming to that conclusion to put that defense together to get the judge to strike this?
Well, Curtis Rogers was the lead attorney on this matter. I came in to assist him. I'm happy that I was able to help him, but this is his case, and he prepared diligently, and I'm proud of him, and I'm happy for Dr. Parker.
Judge Robinson said she had no precedent to work with. Is this a landmark case and a landmark ruling?
I believe it will be, yes. Yeah. Thank you all. Thank you.
Yeah, and again, there were just a lot of emotions in that courtroom today. The moment that the judge made her decision and she announced it, sobs right from Parker in the courtroom. The judge's reason, you know, it varied, but she did say that this was kind of, quote, a mashup of legal theory, noting that these charges, do they stem from the 8 counts based on the bullets or the children in the room or the emotional trauma. So there was just a lot happening, a lot of emotions. Again, the moment that Parker reconnected with her family outside of the courtroom today, they hugged, they sobbed, and again, now she just wants to move forward and put this case behind her. Connor.
Yeah, Brianna, and with you on the screen now, we are showing that video that Brianna was just describing of Ebony Parker, Dr. Ebony Parker, sort of breaking down in the courtroom, releasing that emotion as the decision was read. And you know, I'm stuttering as I watch here, because it really is an incredible sort of sight to behold. You can imagine how much emotion was wrapped up over the course of not just this case, but the last 3+ years. Brianna also spoke about what's next. We did hear from Ed Booth a little earlier, and in regards to what's next, Ed Booth did cite that double jeopardy does apply here. When you swear witnesses and begin the trial, that's the trial, and people cannot be tried twice for the same crime. So that speaks a little bit to what Brianna was giving us there in her live report. Brianna, is there anything else that you want to update us on at this time?
No further updates, but again, I will say just the emotions here this morning were truly incredible. I mean, like you mentioned, you saw in the video the moment the judge mentioned that she was going to strike all 8 charges, and just that reaction from Parker. And again, while we did not get this on camera because it was inside the courtroom in the hallway, Parker did run out of the courtroom and she just hugged her family for just a few minutes before making that exit, Connor.
Yeah, I can imagine. I can imagine. Brianna, we really appreciate all the updates today, all the work that you've done for us here this morning. You guys have been on standby for multiple hours now, so thanks for one last report, and I'm sure we'll see you again a little later on in the day.
Thanks, Connor.
All right, Brianna Fallon from Newport News there with more updates for us. Speaking with attorneys, speaking with Dr. Ebony Parker inside the courthouse, and then a witness to everything as the variety of reactions, right? The prosecuting attorney quickly making his way out of the courthouse. And then, of course, we also had the defense attorney who we got to hear speak there, Stephen Teague. We heard very, very briefly from the lead defense attorney, but it wasn't from Curtis Rogers, but it wasn't anything that we're really able to take any substance from. It was so quick before he actually made his moves out of the courtroom as well. But you heard Stephen Teague, who was assisting him in this case, speaking about how proud he is of the work that Curtis Rogers did. And then, of course, we heard from Ed Booth there, who was able to give us more insight into the technicalities of this whole thing. So a lot of time spent covering this, but a lot of different angles and pieces of information that continue to reveal themselves as the morning has gone on here. Now, I'll bring on Samantha Spinacci with me here as well. She's been producing for us all morning. Samantha, is there anything else that we need to sort of focus on here? Should we take a break and reset, or is there anything else that we want to include in this segment?
Yeah, we can take a break and reset. I think we've played all of the sound that we have in the video showing the emotion in court. We can also play that motion again that the judge read so people can kind of understand why she made the decision. We've heard a lot of the legal analysis, but it's probably good to also hear it from the judge again to kind of reset how that came about. So let's take a break and then we can come back and hear from the judge.
Okay, we'll be right back. Okay, back here on Live Impact News, where we have queued up, we think that we got the timing right as the judge reads her decision here from this morning. This is the moment that we all found out, or that our reporters found out and then quickly relayed to us, and that Dr. Ebony Parker, her legal team, and the prosecution found out that after 3 days and a morning, that the trial would be thrown out, that the 8 counts of child neglect would be thrown out. Let's listen in to that moment.
For 4 days and listen to the motions of counsel. And the division of labor in a criminal jury trial. So in that division of labor, in those legal proceedings, questions of facts go to the jury, questions of law go to the judge. A question of fact asks what happened, and it requires evaluating evidence such as the witness testimony and or physical proof. Questions of law ask how does the law apply to those facts, and requires interpretation of statutes, precedents, and constitutional rules. And that's kind of legalese, with breaking it down. The judge decides the question of law, which is what law applies, procedure, and runs the courtroom. In this case, a criminal jury, the jury would decide the facts, which is what happened. To give an analogy, because this case doesn't put itself well to analogy, somebody is given a ticket for speeding 70 and a 65, but they're stopped in a parking lot. The jury decides the question of fact. Was that driver actually going 70? The judge would decide, does the speeding law apply in the parking lot? So that's the way to wrap your mind around the difference between question of law and fact, which can get quite convoluted. With the question of fact being resolved by the trier of fact, which in this case is the jury, and their job would be to weigh the strength of the evidence and the credibility of the witness, and judges resolve the questions of law. And what would be put to the jury in this case was whether or not Ebony Parker is guilty, and that would be the question of fact. I say all this because the distinction between law and fact can become convoluted, and they can be mixed. It can be a mixed question of law and fact. The Supreme Court itself has acknowledged that it can be an imperfect science of where is that dividing line, but identifying that line is important, critically important, whether or not it's a question of law or fact. Question of fact goes to the jury, they make the decisions. Question of law, it stays with the judge. And I guess for purposes of the party's understanding, that influences the courtroom decision maker, the appellate review, how evidentiary rules are administered, and the application of precedent. Which I will say there is no precedent for what's before the court of an administrator being criminally charged and tried for what has been presented and what happened that day, January 6, 2023, at Richneck Elementary School in Newport News. This court is finding that it is presented with a question of law, which requires resolution by the decision maker. The decision maker on questions of law are the judge, and whose decision is that, and my decision is that this is a matter for the court, and the court is of the legal opinion that this is not a crime, not under the common law of Virginia, nor under the code of Virginia. And the court is going to explain its rationale and ruling. With that being said, if it's not a crime under the common law nor under the Code of Virginia, should the legislature wish to make this a crime, then they will create specific statutory language to do so. When reviewing the statutory language, the court is bound by the plain meaning of that language and must give effect to the legislature's intention as expressed by the language used, and unless a literal interpretation of the language will result in manifest absurdity. So now I look at the statute. Virginia Code 18.2, 371.1. What the indictment charges here is under paragraph B of that statute. It reads, any parent, guardian, or other person responsible for the care of.
Okay, back here in the studio, as you saw once more, that decision read and that outpouring of emotion from Dr. Ebony Parker there. Now, we have obviously a lot to look forward to today. You heard 13 News Now legal analyst Ed Booth giving really great insight into this decision, some of the context, the historical context, the perspective of someone who has been in these courtrooms. He will be live with Madison in Newport News on 13 News Now at noon. Brianna Fallon has just got her live shot up. She's getting ready for our noon show, so head over to 13 News Now for our noon show if you want more coverage of this. For the time being, we will be back at 1 o'clock p.m. on this platform, Live Impact News. We also will have Ed Booth here in our studios, in our 13 News Now studios, for our evening news shows. So later on, 4 o'clock, 5 o'clock, as everyone has more time to gain even further understanding and maybe reaction and updates as to what we've seen here this morning. So looking forward to all of that, but a sincere amount of gratitude and appreciation for everyone who joined us to receive this news this morning. We greatly appreciate it, and we hope that you'll join us again for the rest of the day. For the time being, that's it for Live Impact News here on this Thursday afternoon.